Hi, I'm Anna Denton-Jones, and in today's session I want to talk about the exercise of discretion. And I sometimes come across an attitude within business that if an employer has reserved some kind of discretionary power in their contract of employment, maybe in terms of a bonus or something, that gives the employer carte blanche to do as they like. And that's never actually been the case. It's always been the case that an employer has to exercise any discretion that they have in a rational way, and if the employee could show that it had been exercised in a perverse manner or in an irrational way, then they would be able to challenge it. But of course, that's quite a high threshold to meet. In recent years, however, that threshold has been lowered. And in the case of Braganza, there was a case where an employee of BP was found dead on a trip, and the decision that had to be made, or an investigation was done into whether or not he had intentionally thrown himself overboard and committed suicide, or whether it was an accident of some kind. And the importance of the outcome to his spouse was whether or not she would then qualify under a particular benefit. If he committed suicide, she wouldn't. BP decided that it was a suicide, and she challenged that on the basis of the evidence that had come out in this investigation. And it's from that case that we get this idea that the courts are prepared to look into not only the outcome that's been reached and whether or not that is a proper exercise of discretion, but also look at the decision-making process that has been involved. So since then, we've had the case of Hill, which involved payment of commission and a decision as to how much was going to be put into the pot, if you like, for commission to be split up amongst staff. And in that particular case, the courts were prepared to challenge the way the employer had done it. This particular year, they'd said that the UK allocation of commission would be 48% rather than the sort of 2/3 that it had always been in the past. But there wasn't any particular reasons given for that or documented. And I think the case really shows that in order to show that you have documented a decision-making process properly, there does need to be that evidence of the thought that's gone into it and the factors that have been taken into account. So another example is the case of Simpkin, which related to whether or not somebody was a good leaver for the purposes of a share option scheme. And quite often the rules give the board the power to designate somebody as being a good leaver. So they've got an option to do that, and it's how they exercise that power. In this particular case, the chap concerned had a allegation of performance or underperformance against him, but that had never been to any kind of a hearing. He'd not had his opportunity to have his say about it. It was just an allegation at that stage. It wasn't particularly supported by any particular evidence as such. It was more of an assessment that had been made by somebody. And again, the courts found that when the board considered this issue, it was right at the end of a board meeting, and it wasn't supported by any particular obvious information. Again, showed that really the employer ought to be setting out what is its decision-making process here, what thoughts have gone on to reach a particular conclusion. Another case involved whether or not something should be vetoed under share options, case of Watson, and the board had the power to do something in particular, but again, there was no evidence as to how the board had exercised their minds in making the decision that they made, and the courts were prepared to challenge that using this sort of Braganza line of reasoning. So I think all of those cases really show us that you're not just free to do whatever you like. You should reason your way through the decision-making process and document what the factors are that you've taken into account to reach a particular decision. anytime that there is a discretion involved. And that may involve having to get some advice sometimes as to, what you've done in the past and what maybe you'd like to do this time, and whether or not perhaps this Braganza court case could help you or hinder you in those particular circumstances. Please do get in touch. It's adenton@refreshinglawltd.co.uk. Thank you very much.